You've put in the work, and you're certain that your approach will resonate with the jurors. Or will it? The truth is, you have no idea how these strangers in the jury box will react when you start. Because even if you're an absolute expert at reading their reactions, you won't learn anything until you're already halfway through your opening. And that's too late. But voir dire can give you an opportunity that most lawyers skip right over. I've been a trial lawyer for over 20 years, and I've learned that voir dire is one of the most underused tools by plaintiff lawyers. Most use it to get rid of bad jurors, and that's fine, but that's only part of what you can actually do with it. The part nobody teaches you is that you can use voir dire to test whether your trial theme lands before you even have to commit to it. In this video, I'm going to show you how to test your theme without revealing your case, how to read the room so you know which jurors are with you and which aren't, and the mistakes that can turn your test into a disaster. And at the end, I'll explain what to do if your test falls flat with the jurors. That moment is terrifying, but it can be the biggest gift a jury gives you if you take advantage of it. Before I show you how to do this, let me clear something up, because I know what some of you are thinking. I already use voir dire. I ask questions, I get rid of people who hate lawsuits. Okay, good. Keep doing that. But that's selecting, that's filtering. That's completely different from testing. Testing is about your case. Does your story resonate with the actual jurors in the jury box? You can select what appears to be a perfect panel and still lose, because you never checked whether your theme connects with them. You remove the worst jurors, but you never found out if the remaining jurors feel the way you want them to feel. So how do you actually do this without giving away your case? It starts with one type of question. I call it a value question. And it's the single most powerful tool for testing your theme with real jurors during voir dire. Here's the idea. Your theme should be built on a value, an unwritten rule that the defendant broke. In voir dire, you don't talk about your case, you talk about the value underneath it. A value question tests the belief your theme depends on, without mentioning your client, your defendant, or a single fact about your case. So here's the steps to use. 1, start with your theme. What's the unwritten rule? Then strip out every case-specific detail. 3rd, I want you to turn that rule into a question about life, not about law. Let me give you some examples. Let's say your theme is the defendant rushed and plaintiff paid the price. The unwritten rule is don't rush or cut corners when safety is involved. So your value question can be, have you ever been in a situation where someone was in a hurry and it made things worse? What happened? Let's take a slip and fall case. Your theme is they knew about the danger and didn't do anything to protect people. The unwritten rule is when you know something's dangerous, you fix it. So in that case, your value question could be, if you knew something in your home was dangerous for a guest, what would you do about it? Now, some of you might be yelling at the screen right now, I can't do that. Okay, good. I'm glad you know the rules in your jurisdiction. And the truth is, I might not get away with that one either. In fact, here in New Jersey, we aren't even allowed to ask the question directly. We submit requested questions to the judge, and the judge decides what they want to ask the jurors, and they can choose to disregard any of our questions for whatever reason they want. So you might have to change that question to be more vague and open-ended. I try to have a few options ready. I start with the stronger ones, and I get a little more vague and indirect if the judge doesn't like it. Now, this isn't supposed to be easy. I can give you the framework, but you have to be the lawyer and adopt it to your case. It's a skill you'll develop through experience. It won't be perfect the first time you try this, but don't give up if you get shot down the first time, or else you'll never get the experience. Over time, you'll get an idea of what the judge will let you get away with, some more than others. And this works in any personal injury case. Car accident, trucking, premises liability, medical negligence. Every theme has a value underneath it. Find the value and ask about it. And if you want a step-by-step system for developing your theme and weaving it into every phase of the trial, starting with the opening, check out the free resources I've created for you. The link is in the description below. Now, you've asked the value question. Jurors are answering, but what are you listening for? This is where most lawyers miss the whole point. They ask a decent question, they get a decent answer, and they move on. They're checking a box, probably defaulting to the old habit of only worrying about getting rid of bad jurors. They're not reading the room. When a juror answers your value question, you're listening for 3 things. 1, do they engage or deflect? A juror who says something like, yeah, I'd probably fix it, is deflecting. They're giving you what they think you want to hear. But a juror who says, absolutely, I know if my front step is cracked, I'm not waiting for someone to fall. That's great. That's a juror that feels that value in their gut. Their response tells you the theme will land with them. So remember, you're testing your theme with the jurors, not testing the jurors. Second, you want to see if they use their own language when replying. This is gold. When the juror restates your value in their own words, not only have they adopted it, they own it now. And that language is often better than yours. If your theme is about rushing and a juror says, people who are in too much of a hurry to pay attention shouldn't be driving, write that down. They might have just given you part of your closing argument. This is actually a little psychological trick that is used all the time in marketing. Do you ever get one of those company or product surveys that have open-ended questions? Companies want you to use your own words to describe the problem their product solves, so they can use those same words in their ads. And it works really well. When you can use a juror's own words to describe things, that's as close as you can get to a guarantee that it'll resonate with them. Third question is, does the room nod? Watch the other jurors when someone answers. Are heads nodding? Are people agreeing? Or are they just checking out? People like to be part of a group, and they like others to know when they agree with something. You'll see a lot more nods when another juror is talking than you'll ever see when you're talking. One juror's answer doesn't tell you that much, but one juror's answer plus the room reaction tells you almost everything you need to know. So here's how you apply this. Ask the value question to every juror, not just one. Note who engages and who deflects. Watch the room for their reactions, and write down any juror language that sounds better than yours. Now, before you try this in your next trial, let me save you from the mistakes that ruin the entire approach. The first one is a question that looks like this. How would you feel if someone looked at their phone while driving and hit another car? That's not a value question. That's a fact question about your case. Not only will you probably get an objection sustained against you, but even if you don't, the juror knows exactly what you want them to say. So you aren't getting a genuine response. Also, the defense now knows exactly what the focus of your case will be. So even if they do answer, you've really learned nothing and you've given away your theme before opening. The fix here is to go one level deeper. Don't ask about phone and driving, ask about distraction and consequences. Something like, has anyone ever seen a situation where someone wasn't paying attention and it cost them or someone else? The same value, but no case-specific facts. The second mistake is the hardest one to avoid. You believe in your theme. You want jurors to believe in it too. So instead of genuinely asking what they think, you lead them. It's hard to avoid because you've trained to do it. Maybe you ask something like, well, don't you think that when you know something's dangerous, you should fix it right away? I mean, every juror is going to say yes, and you'll walk away thinking your theme is amazing, but you didn't actually test anything. You got 12 people to agree with a leading question. That's not data, that's confirmation bias. Make sure you ask open-ended questions. Let jurors disagree. A juror who pushes back on your value is the most useful information you can get because they just showed you where your theme is vulnerable, and you can use that information to change your messaging and change your angle before opening. The third mistake's a big one. You ask the value question, the room is lukewarm. Jurors give short, generic answers, nobody leans in, you're not really getting the reaction you want. And what do most lawyers do? Well, they're going to push forward anyway. They'll tell themselves the jurors just need to hear the evidence, they need a little push. That theme will click once they see the facts. The truth is, it probably won't. And if the value doesn't land in voir dire, when the stakes are zero and the jurors have no reason to resist, it's not going to land in deliberation when they're deciding someone's future. That's why you need to have a backup. If your theme falls flat during this testing, you need a second angle ready. It doesn't mean a completely different theme. It means a different emphasis on the same core value. In fact, since I have to submit questions ahead of time in voir dire, I like to have a few different angles in different questions in my pretrial submission, and then by the time the voir dire is done, I know which angle connects the best. But you might need more than a different angle. It might be that you don't have a real theme at all. You might have a legal theory dressed up in better language. That's the most common trap lawyers fall into, confusing a legal theory with a theme. If your theme is really just a legal theory, then testing it with jurors will always give you a flat response, no matter how good your questions are. But I made a video on exactly how to tell the difference and why it matters. So if you don't want the whole case to fall flat from the beginning, then you need to watch this video next.